What are a spouse's or family member's rights to manage property if there is no power of attorney in place?
So this is another unfortunate situation that happens. Sometimes it's too late to do a power of attorney where the person, needs help, but they don't have capacity to sign one anymore. In those scenarios, if they are joint with a spouse, let's say a joint account or whatever, then the spouse has full access to continue operating that account because they're already on it. But if there's a sole account and the person has lost capacity, their spouse cannot do anything without a power of attorney document. So the only solution for them is to actually bring a guardianship application to court. And this can apply to even, non-spouses, like family members that need help, but they don't have a power of attorney. Someone suddenly has a terrible accident and they're in a coma, like unexpectedly, they're young, let's say. There's no power of attorney, maybe guardianship is the only option. Same thing for a disabled relative, for example, someone that was maybe a new adult, was a child, so the parents were able to manage their money all up until they're 18, but now they're having pushback from various agencies. They would have to get a guardianship application. So that is an option. But if you can do a power of attorney, it's much better. It's more efficient. It's less costly. You're not waiting for a court date. You're not going in front of a judge having to prove why you're an appropriate choice, because there's a lot of power that the court's giving you by awarding this guardianship. So it's a very long, extensive application, as it should be. But the easier way is to be proactive and do the document yourself.